Good morning. I'm Marty Sawyer, and I'm the sheriff in Aiken County. Thank you for being here today, especially the citizens of Aiken that's come in. Thank you for being here. And I'm here to provide an update on the investigation that we've been investigating the death of 4-year-old Javeayah Harris. These updates never get easier to share. This past week has been heart-wrenching for everyone, but we've seen an outpouring of support in Aiken County and a massive joint law enforcement effort to search for and now to seek justice for Javeayah Harris. Personally, there's some very harsh words that I would like to use about Javeayah and Michelle and their actions. But I will not do that. And I will not do that to protect and maintain the integrity of this case. But I will tell you this. I will not refer to them as mom and dad or mother or father. They don't deserve that title. I stand before you saying this is one of the most difficult, deeply disturbing, and emotionally taxing investigations this office has ever worked, and it's weighed heavily on this sheriff's office, all these other law enforcement agencies, all these people behind me that's worked tirelessly to bring this to an end, and it's weighed heavily on our community. I am truly sickened to share what this investigation has uncovered. From the moment Javeayah was reported missing, the sheriff's office, as well as our law enforcement partners and first responders, we responded with urgency, determination, and compassion. What started as an exhaustive and complex search quickly grew to something that I would have never imagined. Now understand, I cannot discuss all the details. We should have stopped the train. Understand that I cannot discuss all the specific details in this case. But at this time, I can share that a few human remains were recovered in an area known as Cedar Creek Reservoir, also known as Stumpy Pond in Fairfield County. These remains were immediately sent to the State Law Enforcement Division, and through analysis, the DNA of the remains are consistent with being the biological offspring of Javeayah and Michelle. I want to also share with you that through forensic evidence, statements, and analysis, extensive and deliberate efforts were made to destroy and conceal evidence following Javeayah's death. Our information reveals the use of corrosive chemicals and other tools that were used to accelerate the destruction of her little body. After this was completed, these two individuals poured what remains were left of Javeayah into the Cedar Creek Reservoir. These subjects went through great lengths to cover their repulsive and revolting actions. In my 37-year career in law enforcement, I have never, ever heard of anything so horrific. As a result of this information, it's unlikely that the entirety of Javeayah's body or any other remains from this point forward will be recovered. And I'll say this again, we had all hoped and prayed to find her body, but with the information we've uncovered, that's simply not possible. I want to also announce additional charges for destruction and desecration of human remains have been filed against these two individuals. I know this is heartbreaking for anyone who's followed this case. It's heartbreaking for our office. For all the law enforcement across the state that's worked on this case, countless hours to find every piece of evidence with the hope of bringing Javeayah home. It's heartbreaking to our community. Our commitment has been to pursue the truth regardless of how difficult it may be. While no announcement can lessen the profound loss in this case, our commitment remains unchanged. Today is not only about the evidence recovered, it's about a child whose life was taken far too soon. While today marks a painful chapter in this case, it does not end our work. Our investigators will continue to pursue every lead, examine every piece of evidence, and work closely with the Second Circuit Solicitor's Office to ensure that justice for Javeayah is pursued. I ask you to pray. Pray for Javeayah and her extended family, our staff, all these other law enforcement agencies, and this community. Again, I want to thank all these law enforcement partners, local, state, federal, other first responders who assisted in this case. But from the time I announced at my last press conference that the investigation had taken us outside of Aiken County, I specifically want to thank the State Law Enforcement Division, South Carolina DNR, and Sheriff Will Montgomery and the Fairfield County Sheriff's Office. These DNR divers spent hours and hours and hours searching. Finally, I want to again thank our community. Throughout this investigation, you demonstrated encouragement, patience, and prayers. We recognize the emotional impact this case has had on so many, and we thank you for standing with us. Together, this community has shown that even in the face of tragedy, compassion, unity, and service remain stronger than the darkness we've encountered. I'm going to take a few questions, but if it didn't come from this press release, you're probably not going to get much more.
Sheriff, with how this investigation has unfolded and these additional charges on the parents, at some point, do you have plans to push for the death penalty?
At this point in time, with what they're charged with, that would be a question for the solicitor's office later down the line. I don't want to speak for them.
And what have you guys learned from relatives or other close family about when Javeayah was last seen alive, and whether or not anyone of the close family members had raised any concerns about not seeing her for an extended period of time?
I'm just going to say the same thing I said at the last press conference. We believe that she had been dead for about a month before the 911 call.
Has there been any evidence that you guys have found in the last few days, or when it comes to the child abuse standpoint with Javeayah, that was it one specific incident that potentially killed her, or was it ongoing?
I can't speak on that. I know the answer. I'm just not going to give that.
You all have on the pink ties and the pink ribbons. Can you elaborate on what that means? You mentioned seeing the community here put together this video tonight. What does this mean to you?
Well, everybody's put on Facebook to wear pink. The pink's her favorite color. We just thought it would be, we care about her like everybody else does. We have people that'll be at the vigil tonight.
There are cases that break your heart. And then there are cases that break something deeper than that, something you didn't even know you had until a sheriff stands in front of cameras wearing a pink ribbon on his chest and tells the world in a voice that keeps catching that he has been doing this job.
There are cases that break your heart. And then there are cases that break something deeper than that, something you didn't even know you had until a sheriff stands in front of cameras wearing a pink ribbon on his chest and tells the world in a voice that keeps catching that in 37 years of law enforcement, he has never, not once, heard of anything so horrific. This is that case. And if you stay with it, you will understand why an entire county put on pink for a 4-year-old girl they never got to meet. If this is your first time here, you are watching Midnight Evidence. Hit that subscribe button now, because this is the kind of story that deserves every minute of your attention, and we are going to give it exactly that. Her name was Javeayah Harris. Everyone who loved her called her Ja. She was 4 years old. She lived in Aiken County, South Carolina. Her favorite color was pink. That is where this story begins. Not with a reservoir, not with chemicals, not with charges, but with a little girl whose favorite color was pink, and whose name deserves to be said out loud before anything else is said about what happened to her. Aiken County sits in the western part of South Carolina, a community with a long history and the kind of tight-knit character that means when something happens to one person, it ripples outward through everyone. When Javeayah Harris was reported missing, that community responded. Law enforcement responded. An entire network of agencies mobilized in a way that speaks to how seriously they took what they were facing from the very first moment. But here is the detail that reframes everything that came before the search even began. Investigators came to believe that Javeayah had been dead for approximately 1 month before the 911 call was ever made. That is not a detail that sits quietly. A 4-year-old girl, gone for a month, and the world did not know. The people who were supposed to love her most were the ones who knew, and they said nothing. They called no one. They did not seek help. They did not come forward. For an estimated 30 days, while Aiken County went about its ordinary life, Javeayah Harris was already gone. That month is one of the heaviest facts in this entire case. It raises questions that don't resolve cleanly. It raises questions about what was happening inside that home. It raises questions about what extended family members saw or didn't see, about whether anyone raised a concern, about what a month of absence looks like when no one is looking for you because no one outside that house knows you are missing. The sheriff's office was asked about this directly during the press conference. Investigators were looking at it. But the full picture of those 30 days, what was happening, what was being hidden, remains something the investigation holds closely to protect the integrity of what will happen in a courtroom. What is documented is that when the 911 call finally came, the Aiken County Sheriff's Office responded immediately and with full urgency. Sheriff Marty Sawyer, a man with 37 years in law enforcement behind him, described the response as driven by urgency, determination, and compassion from the very first moment. What started as a search for a missing child quickly grew into something no one had anticipated. The investigation expanded. It moved beyond Aiken County. It began pulling in resources from across the state and beyond, because what investigators were uncovering was not a simple missing child case. It was something else entirely. The joint law enforcement effort that assembled around this case was substantial. The State Law Enforcement Division of South Carolina became involved. The South Carolina Department of Natural Resources sent divers. Fairfield County Sheriff's Office, led by Sheriff Will Montgomery, joined the effort. Local, state, and federal partners all moved together toward the same terrible question. Where was Javeayah, and what had happened to her? The answer was leading them to water, specifically to Cedar Creek Reservoir in Fairfield County, South Carolina, also known locally as Stumpy Pond. DNR divers went into that water, and they searched. Sheriff Sawyer said it himself at the press conference. They spent hours and hours and hours searching that reservoir. That is not a figure of speech. That is a description of what it took. Men and women going into dark water, hour after hour, looking for any piece of a 4-year-old girl who deserved so much more than this. They found something. A few human remains were recovered from Cedar Creek Reservoir. Those remains were immediately sent to the State Law Enforcement Division for analysis. The forensic process that followed produced a result that confirmed what investigators had feared. The DNA from the recovered remains was consistent with being the biological offspring of both parents, Javeayah Harris and Mikala Harris. In plain language, what was recovered from that reservoir was Javeayah. She had been found, not in the way anyone had hoped, not in any way that could offer the kind of closure a family or a community deserves. But she had been found. And then Sheriff Sawyer told the world what had been done before she was put in that water, and the case changed completely. According to the sheriff, following Javeayah's death, corrosive chemicals were used to accelerate the destruction of her body. Other tools were also involved. The process was described as extensive and deliberate. When it was complete, what remained of a 4-year-old girl was poured into Cedar Creek Reservoir. Sheriff Sawyer said in his 37-year career in law enforcement, he had never ever heard of anything so horrific. He used the words repulsive and revolting. He said extensive and deliberate efforts had been made to destroy and conceal evidence. He said these two individuals went to great lengths to cover what they had done. He also said something that went beyond the standard language of a press conference. He said he had very harsh words he would like to use about Javeayah and Mikala, and that he was choosing not to use them, not out of deference, but to protect the integrity of the case. And then he said he would not, going forward, refer to them as mom and dad or mother and father. He said plainly that they do not deserve those titles. When a sheriff with nearly 4 decades in law enforcement makes that statement publicly, in front of cameras, with his staff standing behind him, you are witnessing something real. That is not a prepared talking point. That is a human being who has spent a career keeping his professional distance and has reached the place where this case stripped that distance away entirely. The question worth sitting with, because it does not have a clean answer, is why? Why go that far? Both parents reportedly provided confessions to investigators, as documented in warrants. So the core of what happened was already known to law enforcement. The secret, in the most essential sense, was already out. So what was the purpose of the chemicals? What was the purpose of the deliberate destruction? What was the purpose of pouring whatever remained into a reservoir? One documented answer is legal and practical. A confession can be challenged in court. Defense attorneys challenge confessions. They question the circumstances under which they were given, the mental state of the person giving them, the procedural details surrounding them. Physical evidence is much harder to attack. Injuries documented by a medical examiner, forensic markers on a body, a coroner's determination of cause of death. A physical timeline built from what remains could show. If Javeayah's body was never found, or found only as dissolved fragments scattered across a large reservoir, none of that physical corroboration would exist. There would be no cause of death ruling, no injury documentation, no forensic record that could stand independent of the words two people spoke to investigators. Destroying what remained of her was, in this reading, an attempt to destroy the evidentiary foundation of the case itself. That calculation did not fully succeed. Some remains were recovered, DNA was confirmed, and as a direct result, in addition to the charges already filed, both Javeayah Harris and Machala Harris now face additional charges for the destruction and desecration of human remains. The effort to eliminate the evidence became evidence itself. The other dimension of this, the one that is harder to frame in legal terms, is what the method reveals about the people who chose it. This was not a panicked act. Panic moves quickly and carelessly. What was done to Javeayah Harris's remains required materials that had to be obtained. It required time. It required a sequence of deliberate decisions, one after another, each one a choice to go further. Whatever state of mind produces that kind of sustained, methodical action in the aftermath of a child's death is not something most people will ever come close to understanding. That is not a satisfying observation, but it is an honest one. On the morning of the press conference, the Aiken County community had already begun to gather around this case in the way that communities sometimes do when something happens that is too large for any individual to carry alone. People had been asked through social media to wear pink, Ja's favorite color. That evening, a vigil was planned. Sheriff Sawyer's staff stood behind him at that press conference, many of them in pink ribbons and pink ties, because that is what they could do. They could not bring her home the way everyone had hoped, but they could wear her color. They could stand together. They could say her name. Sheriff Sawyer closed his remarks by asking the public to pray for Javeayah, for her extended family, for his staff and every law enforcement officer who had worked this case and carried it home with them at night, for the community. He said that together, Aiken County had shown that even in the face of tragedy, compassion and unity remained stronger than the darkness they had encountered. Those were not empty words from a man who had been fighting that darkness for 37 years and had arrived at a morning where he stood at a podium in pink, telling the world what had been done to a 4-year-old girl and barely holding the weight of it together. Javeayah Harris was 4 years old. Her favorite color was pink. She deserved every ordinary thing a 4-year-old deserves. She did not get any of it. What she got instead is a community that learned her name, a sheriff who refused to look away, divers who went into cold water hour after hour, and a world that is now paying attention. If this case has stayed with you the way it has stayed with everyone who has followed it, share this video so that Ja's name keeps reaching people who need to hear it. Like it, so that this story finds the audience it deserves. And if you are not yet part of the Midnight Evidence community, subscribe now, because this story is not finished, and neither are we. There are people who harm a child and run. There are people who harm a child and call for help. And then there are people who harm a child and spend the next several weeks making a series of calculated decisions, designed to ensure that no one ever finds out. The last category is the one this case belongs to. And understanding what that category tells us, not just about these two people, but about the pattern that researchers and child welfare advocates have documented across hundreds of cases, is the part of this story that matters beyond Aiken County. You are watching Midnight Evidence. If you have not subscribed yet, do it now, because this case is still moving through the legal system, and we will be here for every development as it happens. What the sheriff confirmed at that press conference was not just the discovery of remains. It was the confirmation of a timeline. Investigators came to believe that Javeayah had been dead for approximately 1 month before the 911 call was made. That means for roughly 30 days, the two people responsible for her safety were not seeking help. They were not telling anyone the truth. They were making a sequence of decisions, one after another, that moved further and further away from anything that could have saved the situation. And by the time the emergency call went out, it had been weeks since any of that was possible. Psychologists who study family violence have a framework for understanding how this kind of sustained concealment develops. It begins with a crisis of exposure. Something happens, an injury, a moment of harm, and the immediate response is not to seek help, but to evaluate the risk of being found out. In that moment, the decision not to call for help is made. And once that decision is made, every day that follows compounds it. The longer the silence holds, the more impossible the truth becomes to tell. Because telling the truth at week 2 means explaining week 1. Telling it at week 4 means explaining all of it. The further a person goes into the silence, the further they have to go to stay in it. That compounding terror, researchers describe, can produce decisions that look completely incomprehensible from the outside, but follow a terrible internal logic. It is not an excuse. It is not a defense. But it is the closest thing to a structural explanation that the documented psychology of these cases offers. What makes the Javeayah Harris case sit differently, even within that framework, is what happened after. Because the concealment did not stop at silence. It extended to the deliberate, chemical destruction of her remains and their disposal into Cedar Creek Reservoir. That step requires a different accounting. Silence can be fear. Silence can be paralysis. What was done to Javeayah after her death was neither of those things. It was planning. It was procurement. It was a sequence of actions carried out over time that required looking at what had already been done and deciding to go further. Whatever internal logic produced the initial silence, the method of disposal speaks to something colder and more deliberate than fear alone. The warrants document that both parents provided confessions to investigators, and investigators understood immediately why the destruction of her remains had been undertaken. A confession can be challenged. A skilled defense attorney can question the circumstances under which it was given, the mental state of the person giving it, and the procedural specifics surrounding it. Physical evidence, a coroner's findings, documented injuries, a forensic timeline, is far harder to dismantle in court. With no body, or a body rendered unrecoverable, there would be no independent physical corroboration of whatever the confessions contained. The destruction was, in the most precise legal reading, an attempt to ensure that even if the truth was spoken, there would be nothing left to prove it beyond words. That calculation failed. Some remains were recovered. DNA was confirmed. And the destruction of those remains became additional evidence against the very people who carried it out. Now it is worth saying directly what the documented data tells us about the broader landscape this case exists within. Because this story does not live in isolation. According to data from the Centers for Disease Control and Prevention, more than 1,500 children in the United States lose their lives at the hands of a parent or caregiver every single year. That figure represents confirmed cases, the ones where investigators looked closely enough to establish cause and manner. Researchers who study child fatality data consistently note that the true number is likely higher, because in very young children, signs of harm can be difficult to distinguish from natural causes without thorough forensic investigation. Cases where no one looked closely enough are sometimes recorded as accidents or sudden illness and never enter the public record at all. The cases that do become public, the ones where a sheriff's office has the resources, the determination, and the forensic technology to confirm what happened, are the ones we hear about. The ones that don't get that level of scrutiny often never make the news, which means the number most people carry in their heads about how often this happens is almost certainly an undercount. That is not a comfortable thing to sit with, but it is a documented one. In South Carolina specifically, child welfare advocates have noted the state's historically elevated rates of child poverty, a factor that research links to increased stress in caregiving environments. Though that context explains nothing about what was done to Javeayah and excuses none of it. What the data does establish is that the general shape of this case, an injury sustained but not treated, a sustained cover-up by two adults, a fabricated story designed to redirect a search, is not as rare in its structure as most people want to believe. The specific choices made here are extreme. The underlying sequence of harm, then silence, then cover, is documented across cases every year. The waiting, investigators and researchers alike will tell you, is often what transforms an injury into a fatality. The waiting is the second catastrophe, layered directly on top of the first. Now let's talk about what the legal process ahead actually looks like, because this is where justice either happens or falls short, and the details matter. Both parents were denied bond and are being held in the Aiken County Detention Center. As of the press conference, both face the primary charge under South Carolina Code Section 16-3-85, which governs homicide by child abuse. That statute was updated and signed into law in March of this year, expanding its application to children under the age of 18, though Javeayah at 4 years old fell under both the previous and updated version of the law. Under this statute, a person who causes the death of a child while committing acts that constitute extreme indifference to human life faces a minimum of 20 years and a maximum of life imprisonment. The version that applies to someone who knowingly enabled the circumstances without being the direct cause carries a range of 10 to 20 years. Court documents indicate the two parents face different provisions of that statute, with different exposure levels as a result. On the question of parole, because it is the question most people following this case are asking, South Carolina law is explicit. If a judge imposes a life sentence under this charge, that sentence carries no eligibility for parole, no community supervision, no early release of any kind, no credits for work, education, or conduct. A life sentence under this statute means what it says. The destruction and desecration of human remains charge, filed under South Carolina Code Section 16-17-600, carries a separate penalty of 1 to 10 years imprisonment and a fine of up to $5,000. That charge runs alongside the primary charge, not in place of it. South Carolina judges have the authority to impose consecutive sentences, meaning additional charges add time on top of whatever the primary sentence produces, rather than being absorbed into it. A false police report charge carries up to 5 years. Stacking all confirmed charges together, with consecutive sentencing on conviction, the exposure is life imprisonment plus an additional decade or more. There is one more provision in the statute worth knowing, because it was written into the law specifically because it has been raised as a defense in cases like this before. South Carolina's homicide by child abuse statute explicitly states that a child's crying cannot be treated as provocation or a mitigating factor in sentencing. That protection is not incidental. It is there because attorneys have argued it before, and the legislature decided in advance to close that door. A judge in this case cannot legally reduce a sentence on the basis that the child was difficult. What a judge is required to consider, on the other side of that calculation, are exactly the factors present here: the deliberate concealment, the chemical destruction, the fabricated emergency response, and the weeks of inaction that preceded it all. Every one of those documented decisions points toward the higher end of the sentencing range. The next formal court date is September 18th. That date is not a trial. It is a status hearing, the first formal courtroom appearance where attorneys will be present, where bond arguments may be revisited before a circuit court judge, and where the case begins its procedural journey. A case of this complexity, with multiple charges, ongoing forensic analysis, and confessions requiring full corroboration, realistically takes a year or more before a jury hears it. The community in pink is going to be waiting longer than September for a verdict. That waiting is its own particular wait for Javeayah's extended family, her grandparents, her aunts, her cousins, who had nothing to do with any of this, and are now being asked to carry grief and outrage simultaneously, while a legal process moves at the pace the law requires. There was a candlelight vigil scheduled for Thursday evening at the event center on Shiloh Heights Road in Aiken, where attendees were asked to bring their own candle, with a walk planned afterward to the memorial at the house on Hillsborough Street. A second vigil was organized for Friday at Foster Park in Union, near the Reservoir, near the county where both parents once lived, near the water that held what remained of Javeayah, for weeks before investigators arrived with boats and drones, and the kind of determination that watching Sheriff Sawyer at that podium made unmistakably clear was personal. Attendees at that vigil were asked to bring a teddy bear. A bicycle giveaway for children was being organized in Augusta in Javeayah's honor. A community that had never met her kept showing up. Candles, pink ribbons, Minnie Mouse toys left at a mailbox on a street in South Carolina. 60 restaurant meals driven 2 hours north for search crews. None of it undoes anything, but it is the thing this community keeps choosing to do, and it is the only part of this story that does not leave you completely emptied out. Javeayah Harris was 4 years old. She was loving and chatty. She was devoted to Minnie Mouse. She chased chickens around a yard. She said yes, ma'am, and no, sir, to strangers. She asked to stay outside until it got dark. She had a favorite color, and the community that never got to know her is wearing that color still. The courtroom will eventually speak to what happened on Hillsborough Street. It will take time. It will take procedure. It will take a jury and a judge, and whatever truth the evidence can still establish, after everything that was done to prevent that truth from being findable. And when it does speak, Midnight Evidence will be here to cover every word of it. Subscribe now so you do not miss a single development in this case. And if this story has moved you in a way that calls for a response, leave it in the comments below. After everything this case has revealed, tell us what you believe justice looks like for Ja.